don't know if you want that.
Welcome.
It's 5 minutes long.
Thank you for coming.
Oh, okay.
Okay, I think, there we go. I'm Marc Levin with TPPF and Right on Crime. Thank you for joining us today for our panel on overcriminalization. We've got some great speakers, and just to set the table for you, what we're focusing on really here today is what should be a crime, which is a pretty fundamental question when we're talking about taking away someone's liberty. And in Texas, of course, we have the penal code, which lists the traditional crimes, stealing, murdering someone. We can all understand those. But then we have over 1,500 offenses outside the penal code. And that's where things get really strange, like the 11 felonies relating to harvesting oysters. But we were able, the session before last, to get the legislature to create a commission to look at all of these offenses outside the penal code, examine which ones we really need, which ones we don't, which ones don't have a sufficient culpable mental state, also known as mens rea, guilty mind requirement, and so forth, which are duplicative as well. And we actually were able to get some of the recommendations through last session, including repealing some antiquated criminal laws concerning secondhand watches. And now we're able to get the commission renewed, so we're continuing our work. And I'm really delighted that Arif has been appointed along with me again by Justice Hecht to pursue this work during this interim and provide additional recommendations for the legislature. You know, a lot of the problem comes in the area of occupational licensing, which you'll hear more about today. But many violations, most of them, of occupational rules are in fact a crime. And one of the really pernicious things is the statutes often say any violation of that agency's rules is a Class A misdemeanor, punishable by up to a year in jail. So every time those rules change, which could be on a daily basis without much notice to anyone, you're effectively creating more crimes by unelected bureaucrats. So these are some of the issues that we're dealing with. But again, we're making some progress in the area of licensing. For example, we got rid of the licensing requirement for shampooers last session. So we're making headway here. So with that, I'm really delighted to introduce what I think is a terrific panel. I want to also remind you about the fact that this is eligible for CLE credit. We've got the forms at the back of the room for those of you like me who have the misfortune of being lawyers. And our Texas Prosperity Promise, which is our pledge to continue to create prosperity and liberty in Texas. I hope you will sign that at texasprosperitypromise.com. Now, our first speaker today will be Ronnie Lampard. He's Criminal Justice Task Force Director at the American Legislative Exchange Council, and I'm delighted to serve on the task force that he runs there, which has been a real vehicle for some superb model legislation that I think he's going to touch on, including in this area. And Ronnie was also a prosecutor in Louisiana, so he brings firsthand experience to this. He also served on the United States Senate Committee on the Judiciary as a legal fellow. And he teaches at Tulane University political science courses as well. So please join me in welcoming Ronnie Lampard.
Well, thank you, Marc, for that introduction. Very happy to be here. It's always a pleasure getting out of DC at any time of the year, but especially during the winter time. It's always nice to come back down south. So, topic today I'm very, very passionate about is overcriminalization, mens rea. I just wrote a white paper on that. It should be distributed out, the state factor, where I just want to let you know the Doors lyrics and AC/DC lyrics in the title of the state factor are completely coincidental and not at all intentional. I did not have the mens rea to do that, so please forgive me. So what Marc touched on was really what I touch on the paper is the growth of the administrative state and how that has led to the promulgation of regulatory crimes. So right now, about 99% of all criminal laws at the federal level were not written by Congress in the traditional sense. That is, they were written by government agencies. And Senator Mike Lee touches on this in his book, Our Lost Constitution, and that these agencies have been given so much authority from Congress to fill up details and create essentially legislation, even though they're not supposed to legislate because they're not part of the legislative branch. So as a result, you have things like bringing a bicycle into the Department of Health and Human Services that is a crime because of certain catch-all provisions, the way statutes are written, and because of the authority Congress has delegated to agencies. And because many of these crimes, because there are so many crimes, and many of these crimes do not have a mens rea or criminal intent protection, people oftentimes don't realize that they're committing a crime. They have no guilty mind. So many states have actually passed a default mens rea or criminal intent protection law. And most recently, those two states were, I can think of Ohio and Michigan. So even though Ohio and Michigan may disagree very sharply about Buckeyes and Wolverines, they do agree that, in fact, there needs to be a mens rea protection. Of course, Texas has had this for a while now, and about 15 other states have also passed a default mens rea provision. And that helps given the sheer number of criminal laws. At the federal level alone, there are 300,000, roughly 300,000, no one knows for sure, crimes that were created by an agency, regulatory crimes, and there are roughly 5,000 criminal statutes created by Congress. So you look at the turn of the 20th century, the number of criminal statutes were in the dozens. And for example, the Dodd-Frank Act has, I think, about 20 criminal statutes within it in and of itself. So that's one statute has more crimes in it than there were at the turn of the century, so 2 centuries ago. So I'm looking forward to a discussion on this panel. Thank you again for having me, and looking forward to it.
Thanks so much, Ronnie.
Thank you.
Well, and I definitely encourage you to go to alec.org. You can see the default mens rea legislation, also the rule of lenity, which basically says if there's 2 or more reasonable interpretations of a statute, i.e. if it's ambiguous, then you adopt the one that's favorable to the defendant, the one under which the conduct would not have been a crime. So let's move now to Representative Matt Rinaldi, who was elected in 2014 to the Texas legislature, representing the northwestern portion of Dallas County. He sits both on the Judiciary and Civil Jurisprudence Committee, as well as the Agriculture and Livestock Committee, and works as a commercial litigation attorney. Representative Rinaldi, thanks so much for being with us.
Thank you. Thank you for having me. I appreciate it. I was actually on this panel, I think it was 2 years ago, talking about overcriminalization. I was very much in favor of reducing the amount of criminalization in our Texas laws at the time. And it was funny because when we prepared for this panel to see what's changed over the past session, my staff gave me a list of very few bills we actually passed that dealt with the topic, and I voted against all 3 of them. So the reason why is something that I suspected that was happening when we were going through session as proponents of reducing the overcriminalization problem in Texas law. I thought the movement to do so was a little bit unmoored. It had become too simplistic in the way that positions were taken on these issues. For example, if there was a law that created a new crime, obviously it would be opposed. If there was a law that reduced a penalty, any penalty for any crime, that would be supported. So there wasn't much thought to a goal in our criminal law, and does our criminal law serve our purposes? For example, I mean, we obviously have an overcriminalization problem. I just printed out an inventory of Texas offenses by category. These are all felonies in Texas. And you look, there's probably about 20 or 30 per page, and I have a whole book here of them. And I mean, you have such things as fraud in a fishing tournament, and that, by the way, is a 3rd-degree felony. And you have making a false affidavit with regard to a county mutual insurance company. Making a false affidavit should be illegal anyway. I don't know why we have these modifiers. A lot of them are occupational licenses, operating a public grain warehouse without a license. So we have all of these offenses. And by the way, I looked for the ones that I thought should be in there, like driving too slow in the passing lane, and that's not in there. But it should be. So, we have all these offenses, and the approach we took last session, where the main bills dealing broadly with it, were number 1, allowing the courts to take an indigent defendant who was fined and taking their income into consideration in determining whether or not to reduce the amount of the fine or let them off with community service. And then the second category was concealing records of offenses. And in fact, that bill even started concealing some felonies as well. So I think both of these are the wrong approaches. For example, in taking income into account, we're taking out the actual enforcement mechanism, the disincentive to commit these crimes. If something's criminal and it's not a civil violation, there should be a severe disincentive to commit this. Secondly, in terms of concealing it, employers, other individuals have a right to know. The trials are public. We have a right to know who's actually been convicted of especially felonies. So I think that's the wrong approach. I think the approach should be reducing the number of crimes. I think the problem is individuals leave the house and may commit several crimes a day without knowing it. And well-meaning people who are committing crimes that are not malum in se, they're just prohibited because of regulatory reasons. They're not morally, morally culpable crimes if we think of it in the most simplistic term. They're regulatory crimes. A lot of them are promulgated by administrative agencies, even on a state level. I think the fraud in a fishing tournament was a state agency rule as well from Parks and Wildlife, but I'd have to check to make sure. So I think that's the issue. We need to focus on making sure that individuals, when they leave the house, know what's prohibited, because our criminal law is so simple that we all can follow it, that it's intuitive, it's in our moral fabric. To know what the criminal law is, at least generally, in the bounds of that. And then once somebody does violate that, then we punish it severely in order to protect other individuals in our society from those individuals who commit those crimes. I do think we made some progress last session in some areas. One was occupational licensing. One of the bills that I passed or passed as an amendment onto another bill was the decriminalization of church security, which I think was very important, especially in light of the tragedy that happened a couple weeks after that bill went into effect. But for example, occupational licensing, because somebody wanted to protect private security services and force churches to pay for private security, it was actually a crime for a church to do something as simple as have a meeting to discuss an active shooter plan. It was a crime, actually, interpreted broadly. It could even be a crime to direct traffic in your parking lot, to take tickets at a door, to lock your door. It was actually a crime to observe somebody, to do anything that directs the movement of people or vehicles. And in case that wasn't broad enough, the last section of the statute said anything close to these things as well. So it was incredibly broad, and we repealed that. It was actually a state jail felony for the second offense to have a meeting to discuss church security. I mean, that's insane. So I think we need to be more, I don't think we need the shotgun approach to our overcriminalization problem. I think we need to reduce the number of crimes and keep the penalties severe for those crimes that are so morally culpable that it's intuitive to us, and get rid of these occupational licensing crimes.
Well, thanks so much, Representative Rinaldi. Really appreciate that. And I think our next speaker, Shannon Edmonds, has been on this panel, I think, for virtually every year I can remember. But always a pleasure to hear his insights on this, especially as a former prosecutor and now Director of Government Relations at Texas District and County Attorneys Association. And he's responsible for a lot of publications, I think, as well as our Twitter feed, which is quite interesting to follow. And but in particular, they put out a publication that lists all of the crimes outside the penal code that's annotated and updated after every session. Definitely recommended for your bedroom reading. Previously, he was Assistant General Counsel to George W. Bush and Policy Advisor to then Lieutenant Governor Bill Ratliff. Welcome, Shannon. Thanks for coming. I believe you've got a PowerPoint as well, so let's make sure we've got that spooled up here.
Thanks, Mark. Thank you for having me again. I think maybe the first time that you and I started to work together was on this issue, when you brought up the fact that this is something that conservatives and people in the law enforcement community might share a common goal, because frankly, your prosecutors back home have plenty of work and they don't need new crimes, right? Ronald and I didn't go to law school because we wanted to prosecute someone for, any of the things that you've talked about here. That's almost more administrative or civil in nature, and when you bog down your criminal prosecutors doing that kind of work, crime victims are the ones who suffer because their cases don't get the attention that they need. So Marc and I have been talking about this for a long time.
Where are we going today, Mr. Peabody?
And so let's get on our Wayback Machine and go back to, I think maybe the first time we had a full panel on this was in 2010, which, hey, my Longhorns were still good at football then for about 4 minutes until Colt McCoy got injured. The first iPod came out, right, or iPad. Flash mobs, remember those? They were all the rage, okay? And TPPF had a panel on overcriminalization of business crimes. So after that, we look at the following session. How did we do? Now, one of the things that we do at TDCA is we track the number of new crimes that the legislature creates every session. And unfortunately, the very next session, the Texas legislature created 51 new crimes. But we did see some progress a couple sessions after that, and then we kind of backslid a little bit last session. So I'm hoping this is maybe 2 steps forward, 1 step back, and that we can make some progress here. But nobody, until I think we started doing this about 15 years ago, nobody was following the creation of these new crimes. And we haven't been able to figure out any rhyme or reason to why it goes up in one session or down in another. I do think that the legislature has made some good strides, especially the House recently amended their rules that govern how they do business to require more notice be given to representatives on the floor when they're voting on things to say, hey, this is going to increase a punishment or this is going to create a new crime. What I think we may need to do more work on is making sure folks look at that when they're trying to decide whether or not to vote for that legislation. The other thing that surprised us when we started keeping track of this is how many new crimes there were, right? And that's each individual session. So add them together. I mean, you're talking over 200 things that used to be legal are now against the law over the past 10 years. And those things rarely go in our penal code. They usually go in the occupations code, which is where a lot of that church security stuff was. It goes in the health and safety code. It goes in the business and commerce code. So it's hidden, even from the practitioners who are supposed to be enforcing it. And if you're going to hide a crime, what good does it do anyone if no one knows it's a crime, both the person who may allegedly be committing it and the people who are supposed to be enforcing it? It doesn't make any sense. So we need to get a better handle on this. I have to give Lieutenant Governor Dan Patrick a hat tip. He clearly saw my presentation ahead of time because he mentioned at lunch today that in California there is a proposal to make it a crime for a waiter to give someone a plastic straw until it has been, or unless it has been specifically requested by the diner. And it's going to be up to a $1,000 fine and up to 6 months in jail for this. Now, this isn't going anywhere, I don't think, but it got filed. And it's an example of how people laugh and forget about it, but there are more serious examples of this in criminal law. And one of them is happening in the Dallas-Fort Worth area. I don't know if you've heard of the case of little Sharon Matthews. She was the 3-year-old girl whose parents are charged with killing her and basically leaving her body out to be found, but they never reported her missing until it was much later. And there is now a move among some people who are very offended that this happened to poor little Sharon, that we need to change our state laws to address this. And they're a group called Love and Justice for Humanity. Don't you love that? I mean, who could say no to that, right? And this is off their GoFundMe page. They are currently soliciting funds to help them create a 501c3 so that they can advocate for changes in laws. They say they're working with legislators. They want harsher punishments for parents and guardians who do not report their child missing. They want harsher punishments for people who pay or who fail to report child abuse. Again, these are things that are already against the law, but they want to make them more against the law than they already are, on the theory that the criminals who ignored the crime before will now pay attention, that it's more serious. And then another thing that they've put forth is a potential new crime for leaving a child at home unsupervised. As the father of 4 young children, you have my attention now. If you're talking about making me a felon because I walk down the corner to get my mail and I leave my kids home alone. Now, again, they're still in the discussion stage. Unfortunately, they're not discussing it with us. They're not discussing it with law enforcement that I know of. And that's a concern because they should be talking to the people who are going to have to enforce these laws. And I'm hoping and I'm inviting them to please do so. Because here's the reality. These are all the crimes that we have right now to address Sharon Matthews' case. Okay, her father is charged with serious intentional injury to a child, which can get him life in prison, and he may eventually get indicted for capital murder, for killing his child who is under 10 years old. The mother in that case is charged with abandoning or endangering her child, which can be as much as a second-degree felony already. We have tools in our toolbox to address many of these situations. But the criminal justice system takes a long time. It's hard for people to be patient, and it's opaque. They don't get to see it, especially in an urban area where a person's never been to the courthouse unless they got summoned for jury duty. So the problem is that there's another reality that we have to deal with when we talk about over-criminalization. And that reality is the eyeballs that get drawn to these stories. Okay? We have an outrage machine industry that sensationalizes these cases and creates in the viewing public a desire to do something right now. And the problem is that you end up with this, which is a cartoon from Pennsylvania on the heels of the Pennsylvania legislature responding to the Penn State Joe Paterno, Jerry Sandusky child abuse cases a long time ago, okay? And I think the point is well taken, is that legislators are going to respond to what their constituents say they want. That's literally their job, to represent their constituents. And so it can be difficult for them who want to get reelected to tell their constituents, their voters, no, I know you feel strongly about this, but that isn't the best way to go. That can be our job, though. We're happy to sit down and talk to those people and explain to them what else is out there, what the potential downsides can be to it, because I think most people who come to this conference probably agree with this sentiment from despair.com, right? I mean, if you think the problems are bad, wait till you see our solutions. I remind prosecutors who want to come to the legislature to pass a law that it's kind of like what Coach Royal used to say about passing the ball. 3 things can happen and 2 of them are bad, okay? So you have to make sure that a new bill is the only solution and the best solution before you decide to go that route. Now, fortunately, the same constituents who bring these to their legislators and ask them to pass these kinds of laws will get the exact same amount of attention as you. If you hear about something like this and pick up the phone or write an email or a letter and say, Mr. Legislator, I know this has been in the news and this is horrible, but this woman's being prosecuted, this man is being prosecuted, he may get the death penalty. We don't need to criminalize well-meaning parents who may not have any mens rea, who may not ever intend that something bad happens to their child. We don't want to make them felons. And legislators will listen. If you give them that cover, then they can say, yes, I know you have this great idea, but I'm also hearing from people in my community who have concerns about this. And it empowers the policymakers to maybe tamp down the interest on this. Because the thing that we were shocked when we first started keeping track of this is almost none of these new crime ideas come from our membership, come from prosecutors, or come from law enforcement. Some do, but a lot of them are just somebody who sees something in the news and they think something has to be done. It's for the children. And sometimes those are some of the worst bills we see every session. And it's a lot of education. It's something that we're happy to do. If you ever have an idea in the criminal law area and you're wondering, what's the current law? is this a good idea? Has it been tried before? You can ring us up. Call me up here in Austin. I will go through the process and do that because I know that for the good of our penal code, that's a service that I can provide to everybody to try to tell you what may or may not be a pitfall there. But don't be discouraged, even though we do on average add 42 new crimes to our state laws and enhance 25 existing crimes every session. I have hope. I have hope, and I have divinely inspired hope that even the good Lord upstairs knows that sometimes less is more.
Lord, I shall give these laws unto thy people. Hear me, oh, hear me. All pay heed. The Lord Jehovah has given unto you these 10 commandments for all to obey.
See, that worked out just fine. So let's get to cutting our codes and stream down some of these laws.
Well, thanks so much.
Thank you.
All right, well, our final speaker is Arif Panju, who's managing attorney at the Institute for Justice, where he litigates for economic liberty, the First Amendment. He's published in the Wall Street Journal, New York Times, many other places. One of the cases you might be familiar with is Patel versus the Texas Department of Licensing and Regulation. He represented a group of eyebrow threaders. I don't even know what that is. I never thought of having that, but they were put out of work when the state began enforcing their cosmetology licensing laws against these folks, and thankfully they prevailed. So he also clerked on the U.S. Senate Judiciary Committee after graduating from SMU Law School. Arif, thanks for being with us.
Well, thank you. The overcriminalization of America has undermined liberty, and it's undermined the rule of law. I think at the state level, at the federal level, and at the local level too, the proliferation of laws and administrative rules has swollen to the tens of thousands. And I'm going to focus on one part of American life where this is taking place, and that is the right to earn a living. What we do each day when we walk out the door and go to work, what we do to put food on our table, to take care of our families, to put a roof over our head. Economic liberty, which simply stated is the right to earn an honest living in your chosen occupation, free from unreasonable government interference, has deep roots in the US Constitution, and it has deep roots in our state constitution. Economic liberty really also underscores a lot of our nation's history. We fought a revolution, and it was triggered when the Crown was, again, preventing folks from earning a living by handing out monopolies. But despite the fact that economic liberty, this constitutional right, is deeply rooted in our federal and state charters, and despite the fact that it's intimately tied to the history of this nation, overcriminalization is having a significant impact on individuals' ability and businesses' ability to exercise their right to earn an honest living in their chosen industry or occupation. One of the key areas where we see this happening the most is in occupational licensing laws. Texas, unfortunately, is not an exception here. This state regulates over 500 occupations. And a lot of the occupational regulations that people are subject to every day are economic regulations that require licensure. Licensure is the most restrictive form of occupational regulation. One of the handouts that you have from IJ has an inverted pyramid, where licensing is at the very bottom, the most restrictive, and at the very top you have no regulation. In between those two things, there's a lot of different, less restrictive regulatory options, and we'll talk about those a little bit later. But licensing, in effect, is an outright bar to entry. You need the government's permission. You need a permission slip in the form of a license to work. And attached to that are all sorts of barriers to entry, whether they're onerous training requirements, multiple examinations, fees. Sometimes you're forced to prove to the government that you've worked for other licensees for X number of years to even qualify to take the test to go off on your own, because the government will finally give you that permission slip. But beyond all of these things, in these occupational regulations, we often find criminal penalties tied in. And unlike these other barriers to entry that lay before someone who just want to earn a living, you've got the threat of having not only an arrest, but perhaps a criminal conviction that will stifle your ability to earn a living throughout your life. And that is a particularly nefarious barrier, distinct from the other ones, because it affects not only those who want to enter an occupation and go through all these hoops, and perhaps don't, and then perhaps they start cutting hair and get arrested. Now, luckily for us in Texas, the Cosmetology and Barbering Code have civil penalties. But it wasn't too long ago in the late 90s where that wasn't the case. So I'll share a story just to highlight what this looks like in real life. In the late 90s, and even today, there's a woman in Dallas named Isis Brantley. She's an African hair braider, is an excellent hair braider. She braids people's hair in her community. She braids the hair of Erykah Badu, Grammy-winning award artist. She travels all over the place. Her services are well sought after. But she was operating her business. She decided to start her own shop. And the now defunct Cosmetology Commission, tasked with enforcing the cosmetology statutes, got complaints from Isis Brantley's competition, who didn't like that their customers were talking about someone else and that this person didn't have a license. So they actually set up a sting operation. They sent 7 officers, a few that were, and also people that worked for the state, the regulatory commission, ununiformed, posing as customers with people waiting outside, and they just arrested her in front of her customers, handcuffed her, and took her away. They put her in a holding cell in Dallas and slapped her with a huge fine. This triggered a lot of reforms that ended up forming a special license for just hair braiders, which was ultimately repealed because Isis Brantley again got tied up into that as well. There was all sorts of onerous regulations that prevented her from teaching her trade. That's what it looks like in practice. But it's not just confined to people who want to enter an occupation. These occupational licensing laws also, once you've entered the occupation and get a license, then saddle licensees with all sorts of red tape. And if you don't comply with the licensing regime, you also can be subject to criminal penalties. And it can prevent you from ongoing in that occupation and continuing to earn a living. So to give a very recent example, this is from a few weeks ago. There is a gentleman also in North Texas, not picking on North Texas, named Shane Gatlin. Shane was someone who's operated a locksmith business. He's grown it over 3 decades. He has employees. He's doing well. He's served hundreds of thousands of customers. And before he was licensed, and his license has been renewed dozens of times, a dozen times. But this last time where he needed his license renewal, the private security board decided, no, there's actually a problem here. We know that you actually told us that you had a conviction from 40 years ago. And Shane had a conviction on his record for being a getaway driver when he was 19 in a residential robbery. He got probation, he completed that, he ended up becoming a locksmith, he got his license, he disclosed this conviction way back when, and he had his license renewed. But this time, they decided to bring that up and not renew his license. There was a bunch of reporting that took place around this because he decided to fight it through the administrative courts. So again, he wasn't able to renew his license, disruption of his business, drug through an administrative legal process, had to hire an attorney. The recommendation from the administrative law judge was to let him renew his license, and the private security board ultimately did that. And so overcriminalization has permeated occupational licensing regulations and economic regulations. It affects people that want to work, it affects people that are licensed, and it's a significant problem. Now, the good thing for Texas is that we're talking about this issue. The good thing is that there's representatives that are working on this issue, and that there's folks that are engaged in the law enforcement community and in the legislative side, policy making, that all identify these things as actual problems that need to be taken care of. And so there's perhaps 2 important things I think that could help steer things in the right direction. One involves policymakers and lawmakers. The other involves the courts. On the legislative side, there needs to be a fundamental rethinking of how we regulate people's livelihoods, how we regulate their occupations. Texas used to regulate one occupation with a license, doctors, way back when this was a republic, Texas. Today we're up over 500. And one of the reasons that overcriminalization has permeated these regulatory schemes is because of licensure, because it has a mandatory barrier to entry where you can attach all sorts of red tape and penalties to it. So the key is to shift that away from licensing to less restrictive regulatory options, whether it's simply requiring registration with the government, whether it's simply requiring someone, if they want to, voluntarily, to get a certification by completing a bunch of things and proving that they can call themselves a state-certified whatever, or bonding, or disclosure. There's all sorts of less restrictive things other than licensing, and reserve licensing to very select occupations. Now, I know that will anger a lot of folks that represent licensees who lobby for more laws and make their license a greater barrier to entry, less competition, higher prices. But lawmakers have introduced these bills, and they're getting reelected. And they have great stories to tell on what they're trying to accomplish, and more lawmakers should join in. On the legal side of things, in the courts, Texas is one of the few states in the entire country where your right to earn an honest living now receives meaningful constitutional protection. In most states, especially under the federal tests that are applied in these cases, the government can make up the reason for the law. Evidence does not matter. In fact, the judge is tasked, and oftentimes, with helping the government justify the existence of the law. There's all sorts of due process problems there. Usually you should have a neutral adjudicator, not an Article III co-counsel on the other side. And what happened here in Texas, first in the Fifth Circuit, is that the Fifth Circuit said, look, the government can lay out their reasons for a law, but plaintiffs get to adduce evidence and use evidence to undermine those justifications, and laws can get struck down. Economic regulations can get struck down. And they struck down a licensing law on funeral directors that prevented the monks of St. Joseph Abbey from building their caskets and selling them to the public. A very controversial thing, but a great ruling for economic liberty. It was the first time that an occupational licensing law was struck down in the Fifth Circuit since the New Deal. In 2015, 2 years later, in Texas, at the Texas Supreme Court, in a case that involved eyebrow threading, and I recommend eyebrow threading to everyone, although perhaps anyways, you should go try it. You should go check it out. In a case that involved eyebrow threading, which is a practice of using a piece of cotton thread to shape eyebrows and pluck little tiny hairs, the case rose up to the Texas Supreme Court because the courts were unsettled on what test governs challenges to economic regulations. And the Texas Supreme Court held, in striking down the laws that were being applied to the eyebrow threaders, that, look, you're not teaching eyebrow threading in these courses at the cosmetology schools that you're forcing people to go to. You're not testing eyebrow threading on these exams that you're forcing people to get. So why are you forcing them to get this license just so they can go back to doing what you're not teaching or testing them? And the court laid out a standard of review that said, we have to look at evidence, we have to look at the real world effect of the law, and we have to see whether the law, even if it does have a connection to a government interest, is so unreasonable and oppressive that it fails the constitutional test that's at play. These two things make Texas a special place to do business because it creates a ceiling with respect to constitutional limits, limiting the proliferation of economic regulations. And that really helps on the overcriminalization front because now we're starting to narrow where the focus should be. And so thanks for having me on the panel, and I'm happy to take any questions afterwards.
Great, thank you. Well, let me ask one question, and before we go to the audience questions, which is, sometimes what we hear at the legislature is, why should you be so concerned about this? Because prosecutors are never going to enforce these laws. And Shannon's absolutely right. Most prosecutors have much better things to do, more important things to do. But it is interesting because I did just find, for example, 2 people in Texas have been charged with one of the crimes the commission recommended getting rid of, slandering a savings and loan. Which they must have had a great lobbyist, those savings and loan associations. So there are occasionally people that do get charged with these, but I wanted to just ask, do any of you see there's a reason to get rid of some of these obscure crimes that are never charged, even if they have never been enforced? Should we still be concerned about them being a threat to liberty?
Yeah, absolutely. I mean, the point is they're the first step to the government abusing its power and targeting specific citizens. I mean, you always hear the Stalin line, you find me the person, I'll show you the crime. That's basically what we're doing, right? Every one of you is guilty of something. If we look into your past, I mean, it allows the government to act tyrannically. Another issue is not all of these are obscure crimes. I mean, we had crimes that we were addressing, like failure to pay tolls, and we repealed the criminal part of that statute in the House, and it got put back in conference committee. We also, the occupational licensing laws especially. I mean, these are things people are forced to follow. You brought up cosmetologists and hairdressers. There's actually a bill on local and consent calendar that added a requirement that that hairdressers be trained in domestic violence and dealing with domestic violence. And the rationale for it in the bill was a lot of people talk to their hairdressers about their problems. Honestly. Local and consent calendar, we ended up knocking it off. But another bill got passed that actually requires hairdressers to take training on human trafficking. And that got added to the statute. So these aren't all obscure, I want to point out.
And it's important to note where the call for these laws is coming from. It's coming from folks who have both, they have two things. They have the incentive and the means, so the financial incentive and the means to pursue these laws. So in the cosmetology realm, those, if you look at folks that are really active in it, it's the people that own the schools. By law, you're forced into those schools because you have to spend 1,500 hours in those schools just to be able to qualify for a license. And the more things they can tack on to that curriculum, the more time you're going to spend and the more tuition they're going to charge. It's one of the very few occupations where the state forces people to go into a specific curriculum. If you want to be an EMT, you're spending less than 200 hours to get a license to become an emergency medical technician saving people's lives. If you want to simply use scissors to cut someone's hair, you're spending 1,500 hours and taking 2 exams and perhaps trying to also learn about domestic violence so you can talk to your potential customers. It's the severe mismatch across the spectrum of occupations is really revealing, and it reveals the source of the problem, and which is the folks lobbying for these laws are those who have the means to do so, and they disperse the costs across everyone else.
So we'd like to open it up now for questions from the audience.
Quick question is, do you see any possibility in the legislature of the dope user, the small one, being treated as a medical problem rather than a criminal problem?
Well, that's a good question. Yeah, sometimes when people see overcriminalization, the first thing they think is drugs or prostitution. So the word often can connote many different things, which is obviously a lot different than some of the business-related matters we've been talking about. But who would like to chime in on that?
You can defer to the legislator if you'd like, and then I'll go. But I'm happy to take a crack at it if you'd like.
Okay. Maybe marijuana in particular.
I could tell you in Texas that those proposals there have been proposals made to decriminalize possession of small amounts of marijuana, for example. I think one of the large issues with those is I think they overshoot. For example, possession of a small amount for personal use is often defined as much as 2 ounces, which if you've ever seen 2 ounces, it's not really personal use unless you're having a really long day, I guess. I don't know. But so I think they overshoot. I think if you made it maybe 1-2 grams, made it actual personal use, it would go somewhere. But the problem is I think they're overshooting.
And I would just add, I think the trends in the states is certainly to offer treatment programs to small-time users. But as far as straight decriminalization, that hasn't really picked up a lot of steam in many states. But there is this trend that this person who may have if they're addicted to heroin, they may have a substance abuse problem and would be better served, and the community would be better served by that person getting treatment than that person going to prison. But it's still an underlying criminal offense, and the rationale is that people say, well, we want to keep it a criminal offense to keep that person accountable, saying, hey, we can give you treatment, but if you don't comply, then you could potentially go to prison. So that's really the trends that I've been seeing.
The problem is once they're tattooed as a felon, they're basically limited to manual labor for the rest of their lives.
Sure, and that assumes conviction. If the person goes to treatment and completes treatment and does not ever get convicted, then they don't have that conviction on their record, which helps them. And that ties into, again, the occupational licensing angle, where someone may have committed a crime 15 years ago, and that person is still saddled with the responsibility, even though they've repaid their debt to society, and are facing serious barriers to reentry.
Well, and I want to encourage you to come to our panel tomorrow because one of the panelists, the district attorney from Harris County, has implemented a diversion program for marijuana offenses. It was actually started under a predecessor, but she's expanded it. And I think she'll talk about some of the successful results they've had with that. But basically, if you go to treatment or a class or whatever, it's like an 8-hour commitment, then you have nothing on your record. So that's certainly one way a lot of jurisdictions in Texas are starting. I know they've started stuff in El Paso and San Antonio similar to that as well for low-level marijuana possession. Oh, down here.
I guess this is for Representative Rinaldi, but also for probably ALEC, are you seeing like a huge swing in push for harsher penalties for mental health after some of the crimes we've seen committed in recent years about people saying, oh, this person had a mental health background, they should have never had a gun, or they should have this, or they should have that. Are we going to swing the pendulum too far in the direction where we label people that really aren't mentally ill as having, you know, a way to overregulate? I'm worried about overcriminalization on the mental health side because we're constantly hearing about needing to, tighten our laws to handle and deal with the mental health issues in our state. So I'm just curious about that.
Well, I'm thinking you gave an example of our gun laws and reporting for mental health, and I think that's a different issue because what that has to do is state reporting of known individuals with mental health impairments being sent to the federal database. I think Ted Cruz and Grassley had a law that would have helped deal with that on a federal level as well. It was filibustered by Democrats, incidentally, but would have helped shore up the background check laws. As far as mental health, we've gotten, I guess, generally as a society, we've gone where we don't help the people who need it most because we've erred on the side of not helping people who don't want to be helped, but sometimes people can't functionally seek help, and those are generally contribute a lot to our homeless problem and people that you see on the streets. I do think we need to do something for them, and it starts with mental health.
Yeah, and I'd like to add, mental health treatment was one of the primary things that prosecutors were interested in obtaining more of last session because what they all see in the criminal justice system is the failure of the mental health system, right? People are ending up there. The Harris County Jail is the largest mental health facility in the state for a reason. It's because, unfortunately, a crude way of saying it is it's cheaper to treat them in jail than it is to treat them in a state hospital by a factor of 10. Okay, and so our members were very encouraged to see the legislature put, and this is something that Governor Patrick alluded to at lunch, put $300 million towards shoring up the existing beds that we have, and HHSC is looking at where they can add a couple of hundred beds for treating these people so that they don't end up in the criminal justice system. Because, that stat he gave about Texas has grown by 10 million people over the last 15 or so years. We essentially added 0 state mental health beds over that period. We added 10 million people to our population and did not add a single state mental health bed. And that is it's so short-sighted. Yes, it is expensive to do, but in the long run, it is going to save a lot of money for both state and local governments, and we're going to help these people. So that, I think, is, even if you consider yourself very fiscally conservative, that is an area where you are getting good bang for your buck if you are appropriating money towards that purpose, because in the long run, you're going to save tenfold of what you are spending.
Well, and just to amplify that, they're still going there eventually, but they have to wait 150 days in the jail, local county jail at taxpayer expense, before they can go to the state hospital bed for competency restoration.
Oh, there's some people who wait a year before they can, in your county jail, before there is room for them to go to a state hospital and be brought back to competency so that their case can proceed. Legally, we can't do anything with them.
And one of the problems, too, is it always starts with a case, right? You have people on the streets of downtown Austin sometimes who are visibly psychotic or schizophrenic, and they're not receiving help, and they can't physically seek help for themselves. you know, we shouldn't wait till they're convicted of a crime to help them.
Our chair, Wendy Graham. So glad you're here.
Oh, thank you very much. I have a question. Licensing, I think, is pernicious, and it occurs across the state. And I heard of a cases where in the military spouses move with their husbands who are serving, and they might be licensed in one state and can't practice, you know, washing your hair or whatever it might be in other states. And I wondered if there might be something that this state could do in legislature that would waive legislatively the requirements. You can start with the military, okay? Military spouses would waive certain licensing requirements and be able to practice in Texas if they have a license somewhere else. The point being is that it's a little bit of a nose under the tent, and you could maybe develop some reciprocity with other states, but ultimately, I think it's very difficult to get rid of licensing requirements, as stupid as they are, because of all the special interests. So is this a way?
Yeah. So the most portable license is no license at all, right? I mean, that's a no-brainer. But speaking with the status quo that we have right now, Texas could, on its own, say, anyone in any other state that's licensed, come here and work. Now, we ran into this actually in an interim hearing on Hurricane Harvey in the Senate Business and Commerce Committee. I gave the example of HVAC contractors. In Texas, it takes 4 years of working under an HVAC contractor to even qualify to become one. And, you know, there are tens of thousands of homes that are flooded. They need HVAC systems and work. So not only can Texans who know how to do this, but cannot, because under this regulatory scheme, they have to work under someone else. But TDLR had set up some rules to make it, quote, easier for people out of state to come in. And if you look at the rules, they're required to, quote, work under a Texas licensed contractor instead of just coming and working, which doesn't make any sense. Texas, I think, only has 2 states that have reciprocity in the HVAC space, South Carolina and some other state. Not Louisiana, Oklahoma, New Mexico, not the closest places. And it really highlights the problem. There is no harm to the state to allow people to come here and earn a living. In fact, that's the very basis for a lot of what folks in office here in Texas say, that this is a great state to come here and work. But we have these rules that don't allow reciprocity because, you know, if the other state's not allowing us to go there. Well, we don't want to go there. We want them to come here. So let's just open the door entirely. It's a really easy fix. And then we can start repealing all these licenses.
And just to add to that, if I may, fortunately for Texas, Oklahoma has criminalized the unlicensed practice of cosmetology. So but unfortunately, with the military example you gave, if someone is stationed in Texas and then goes to Oklahoma, and the military wife or whomever, the husband might be a cosmetologist but not might be licensed, that person is now a criminal in another state, in a neighboring state that has a large military presence. So as far as Texas goes, Texas might not criminalize that practice, but you have a neighboring state that does, and that does make things difficult. But again, Texas is much easier to practice cosmetology in than, say, Oklahoma, so that benefits Texas.
Down here.
I want to talk about the car seat manufacturers' lobby. They must have a big lobby in the state of Texas because we have grandchildren. And the terror, if you don't have the right car seat for this child. I nursed 4 children for 10 years in the back seat of our car. Now you can't do that. If the child is crying, you got to stop and pull over and nurse the child. Who made up these laws?
Yeah, I'm with you. I'm with you on the car seat stuff. I'm around the people all the time who make these laws and think it's a great idea. No, my wife and I were just joking yesterday, actually, when we were talking about when my kid was going to grow out of his car seat, and we were trying to figure out. Yeah, well, we figured we want to buy a car seat we can use for the next 60 years, because that's probably what the law is going to be when he's like 60. Yeah, it's ridiculous. Because it's for the children, right? And the reason why I was the only rep who registered to vote against the cosmetologists taking sex trafficking training was because it's a sex trafficking bill and nobody can oppose it. So, you know, the way that you look at a bill as a legislator, the way that many legislators look at a bill when there's 8,000 bills proposed is, oh, what's that? It's an immigration bill? Okay, I'm for that. Is it a sex trafficking bill? Sex trafficking's good. I don't want to deal with that in my campaign. Car seats protect the children. That's exactly what I'm going to do. And they don't go deeper than that. That's the problem.
Yeah, and I'll just say, again, as a father of 4 kids under 12, okay, I've had to buy vehicles large enough to have car seats for all my kids in it so I can take them to school in the morning, because I take them to school every morning. I will say a little bit of me wants to tip my hat to the lobbyists who made it a crime not to have their product. I kind of appreciate that from a professional point of view. But I mean, think about that. They've made it a crime if people do not use their commercial product. It's, I mean, you know, I love my kids. I'm not going to do anything that's going to endanger them. And you can't just, you know, do you have a booster? Do you have to have a 5-point harness? It's very frustrating, and it's in a way discriminatory against against large families. Yeah. And so it's very frustrating to see that kind of feel-good, do-it-for-the-children legislation that no one wants to oppose because they're worried they're going to see it in a flyer in their next campaign.
Now that does remind me, remember the legislation that would have licensed lactation consultants? Do you remember that bill? That did not pass, thankfully.
I'm not sure this panel is the appropriate one to talk about these issues, so I'll defer to that.
Well, no, thank you for bringing that up down here.
I'd like your comment I'm on a couple of items. One has to do with the fines that are out there, and they're overfined for certain instances, and the other thing is over prosecution in certain instances. One case in Wyoming, a small rancher got permission to put a little pond and on a stream that comes through. He was ultimately taken to court, federal, so I'm talking about federal, for damming up. Now, he already had permission from the state, but the feds came in, $75,000 a day because of some deal on misusing waterways, damming up U.S. waterways. It was ultimately found that it didn't do that. That never went into any stream that got to the ocean. But $75,000 a day, that's the first question. How do we stop that kind of stuff? And the second item is a guy that I've met, had a CEO of a public company, that did healthcare, new technology for a certain type of surgery. One of his salesmen made a comment, a portion of this technology could not be used for a specific item. They were still trying to get it approved. One of his salesmen made a comment. The feds came in with federal prosecutors, and their intent was to put the CEO in jail. And he spent $40 million to fight this. His board backed him. $40 million, 120 lawyers to fight this case because if some of his salesmen didn't lie so they could put him in jail, then they were filed with a crime. So how can we have prosecutors at the federal level doing that, and when it's all over, which it is now, and nothing's happened to those prosecutors at the federal level? They are still federal prosecutors. How do we get past these two items?
And another one, Ted Stevens, you know, there wasn't much accountability for that. Turned out to be a wrongful prosecution. And Shannon, I think you said in the past that this is, you said at maybe one of our previous panels on this, that it is more of a concern at the federal level because maybe most state prosecutors are just so busy with your those things we're all frankly agree should be crimes.
Yeah, I'm not here to answer for, excuse, or defend anything the feds do. I'll tell you that. And part of the reason is because I think as a, and this is just me personally, as a former state prosecutor and our members realize that, the feds have cast the net of their criminal jurisdiction so wide that it creates a lot of resentment among state-level prosecutors in that they only take the easy, best cases when there's a dual jurisdiction, and they leave their state prosecutors and local officials with the hard cases or the crappy cases. And so there's some resentment there, but also that it's just what interest is it to the federal government oftentimes that someone is doing something that is already covered by a state offense. Because you can be prosecuted for both. That's legally not double jeopardy. You can get convicted for running drugs by the state of Texas, and then the U.S. government may come over and prosecute you for running those same drugs. And it just doesn't make much sense. It seems to me like it's run amok a little bit. And in many of those cases, it sounds like it's something that Congress has delegated to the administrative branch to create some of these crazy fines that may be appropriate if you're going against somebody with a market capitalization of $150 billion, but not a sole practitioner or a one-man shop. And it's because the criminal law is a blunt instrument. And so it should be used, this is just my personal opinion, it should be used much more rarely because many of this stuff is, I'm sure there were probably other state laws that could have been used and were probably not nearly as punitive in those cases.
And then in some, like Medicaid fraud, you have a third layer of government as well. So you can be prosecuted by the AG, the DOJ, and the OIG here in Texas. And then you got a plea bargain with 3 different government agencies in order to try to get them all to agree to a settlement.
And if you, go ahead.
To really prevent, to the point of preventing the growth of crimes and preventing these crimes that are outlandish, ridiculous, if you will, if something is serious enough that a person could go to jail or prison for, Congress should not delegate that authority to an executive agency.
Yeah.
Congress should make those crimes, not an agency. The elected representatives who have constituents who represent them and who are held accountable to those constituents should be making those crimes, not an unelected bureaucrat. And that's where the vast, vast majority of the crimes come from. And in situations where you have an individual who's saddled with a $75,000 fine per day, oftentimes those are creations of executive agencies.
So how many, one of the surprising things to look at is how many laws do you think Congress passes now per year? Just offhand. It's usually about 100, around 100, sometimes a little more. If you look 100 years ago, it was about 100. Congress still passes about the same amount of laws every year. It's the administrative agencies that have just ballooned everything.
Yeah, and of course the length of some of those, like you brought up Dodd-Frank, Sarbanes-Oxley, Obamacare, those all had criminal penalties and they go on for thousands
we
of pages.
We need to appoint judges also that are going to get rid of Chevron deference and make sure that the administrative agencies have less power.
Yes, absolutely. And even what's less than 100 is the amount of economic regulations that courts strike down every year. Courts just got out of the business of enforcing the protections for economic liberty after the New Deal. And the vestige of the New Deal jurisprudence has landed here today in just explosive amounts of economic regulations and almost no engagement by courts. They like to parrot the line, which is really rooted in majoritarianism. Well, we'll just defer to the legislative and administrative branches, whether it's Chevron deference for administrative deference or just deference to the lawmakers. We're just not going to strike it down. Well, constitutional rights were never intended to just be there at the whim of majorities. We're a constitutional republic, and our courts have a duty to treat all rights and enforce meaningful protections for those rights. But putting economic liberty in the constitutional junk drawer and allowing folks to just make up reasons for laws and then the judge rubber stamping them is not judicial review. And once courts get back into the business of striking down laws that just don't pass constitutional muster by looking at evidence and holding the government accountable, you're not going to have the check on the other two branches in the economic realm that our framers intended there to be. But things are changing. In Texas, the Patel case is definitely a huge step in the right direction.
Yeah.
And lawmakers are paying attention as well, and also advancing, principled approach to legislating that takes that right seriously.
And the Patel case is huge because, I mean, you're going back to, judges have been making, since the New Deal court, judges have been making up new rights that don't exist anywhere and were not intended to exist anywhere in our Constitution, whether it be abortion or contraception, which should be a legislative issue, and forgot about economic rights. So the property rights enshrined in our Constitution generally are not judicially protected. Congress can tax you up to 100% tax rate, and that would be constitutional under today's jurisprudence. So I do think we need to get back to that. I thought the Patel case was wonderful because it was kind of a return to that.
Yeah, and one of the examples is the right to contract in the U.S. Constitution that's been completely read out by the courts as if it doesn't exist. We have some other questions. If not, I will pose one. One of the issues that came up was, in the case involving the locksmith was, do we have another?
Yeah.
Oh, okay. Well, very good.
What impetus for licensure and certification comes because governmental agencies at every level, when they contract with an entity for something, a service, want to make sure that that entity is competent, and therefore they need to be licensed or certified so that the state agency, the federal agency can say, we let this contract out to people who were demonstrably competent to do it, rather than just Fred or Sue.
Right. I mean, the easy
do a
answer
certification.
Right. They can be voluntary certification. So the state can say, well, contract with people who are state certified, enter the occupation. And to get that credential, a voluntary credential, you do, whatever the government is asking you to do. Or, the government can say, well, we'll contract with people who are certified through this independent, organization. And get licensing out of it, because licensing has all sorts of negative repercussions, and it drags in all this overcriminalization into this licensing scheme as well.
Well, my question was, so we have this locksmith who got a favorable recommendation from the State Office of Administrative Hearings, and I was actually surprised. I think it was only because of some excellent coverage in the Statesman about the case, but the agency, the Private Security Bureau, did ultimately agree with the recommendation. But more often than not, if I'm not mistaken, the agency chooses not to comply with the state administrative law judge's ruling, which means the person then has to go to district court, which again, more legal fees. Meanwhile, you don't have your occupational license, you're out of work. So should we consider perhaps saying that if the administrative law judge rules in favor of the claimant, like this locksmith, that the agency would be required to comply, or the burden would be on them to go to district court to get an injunction?
Yeah, I mean, I think that would be a good solution as well. I mean, there's a lot of different things we can do. That's certainly one of them, I think. I think we need to rethink the way we look at regulation. What we do now is we have criminal penalties for violating these occupational licensing regulations and other regulations as well, instead of prohibiting the bad conduct. And sometimes the decriminalization movement is so focused on reducing penalties that we're reducing penalties for the actual bad conduct too. The way law should be structured is there should be very few crimes, they should be very specific, and they should be punished very heavily so that the deterrent effect makes it unnecessary to have all of these little regulatory crimes.
Well, I guess that brings us back to the 10 Commandments. Well, I think we're out of time. But I want to thank everyone for coming, and I hope you will join us for the rest of our sessions later today, and most of them are tomorrow at this point. So thanks again.